Good afternoon and welcome to the webinar. My name is Katie Bruno and I'm a financial planner with Maureen Quinn Wealth Partners in Omaha, Nebraska. In today's webinar, I'm going to be discussing the SECURE Act, Setting Every Community Up for Retirement Enhancement Act. I am recording the webinar and it will be available on YouTube in the next few days. If you're not already following me on YouTube, please go out to our page, like it, follow it. It is Maureen Quinn Wealth Partners. If you have a question, I will be opening it up for questions at the end. So feel free to post them on here. But if it's a question that you really need one-on-one advice or want to have a conversation around, feel free to contact me with my contact information listed on this slide. So today's webinar, we're going to discuss what is the SECURE Act and what was the SECURE Act designed to do. We're going to go through the provisions of the SECURE Act and then talk about what happens next and what you should do if you might be affected by the SECURE Act. So the SECURE Act is Setting Every Community Up for Retirement Enhancement Act. This was the biggest change to the U.S. retirement system since 2006. In 2006, the Pension Protection Act of 2006 was passed, and this was a comprehensive bill that was designed to reform U.S. pension plan laws and regulations. The SECURE Act also affects retirement and retirement plans. The act was attached to a spending bill that was passed in December with bipartisan support, and then later signed by President Trump. And it was effective immediately starting in 2020. And the goal of the legislation was really to address the retirement savings crisis that's looming in the US. Studies show that only about a third of Americans have no retirement savings at all. And so when we think about that, and we think about how corporations aren't offering pension plans, or many corporations are not offering pension plans anymore, people are healthier and they have access to amazing medical treatment. And so all of these things combined, and people are living longer, it really creates a deficit in retirement savings. And so what this piece of legislation does is it was designed to put into place things that affect people's ability to save money for retirement. And it influences how people are able to use that money over a period of time. There are 29 provisions and changes within the piece of legislation, which is far too many for me to cover today in the webinar, but I do believe that I'm going to cover the most important ones. So we'll start by talking about the provisions of the SECURE Act that affect individual retirement accounts, or as we know them, IRAs. And so the changes that were made to IRAs are really to account for increases in life expectancy. The SECURE Act, the first thing it did is it repealed the age limit on contributions to traditional IRAs. So because people are living longer, they are working longer. And prior to this legislation, once you reach 70 and a half, you are no longer allowed to make a contribution to your traditional IRA, even if you were still working. So now with the SECURE Act, you can make a contribution to your traditional IRA if you have earned income. One of the single biggest impacts for existing IRA owners in the SECURE Act is the change in the age for the required minimum distribution. So a required minimum distribution is money that you must take out of your account, either your IRA or your 401k, when you reach a certain age. And it's calculated by using a formula the IRS sets, and it's based on, your age, the value of your account on the last day of the year, sometimes based on your beneficiary's age. There's several different factors that are put into this formula. And so the IRS used to require that you start taking the money out at 70 and a half, because when you take the money out, you also pay taxes on the money you take out because it's considered income. And the age 70 and a half has not been changed since 1960. And people are living a lot longer today than they were in 1960. So now what is happening is we have increased the age that you must start withdrawing money to 72. Now this change applies to anyone who turned 70 and a half this year or later. So if you turned 70 and a half before December 31st, 2019, you will still need to take your first RMD in 2020. Required minimum distribution, also referred to as RMD. So I know there's been some questions from my clients who are in the middle of these ages. You know, they started taking their RMD in 2019. Now, can they skip a year and go to 72? No. If you've already started taking your required minimum distributions, you have to take your required minimum distributions. If you turn 70 and a half in 2020, you will delay your required minimum distributions until age 72. The other thing affecting IRAs is that it eliminated the stretch IRA wealth transfer strategy. So the stretch IRA is a IRA that has been where the account owner has died and somebody has inherited it. So it's an inherited IRA. And what it would be is if you received money, a non-spouse beneficiary, you received money, you could take required minimum distributions from that account based on your own age until the money was gone. But under the new rule, it says if you've inherited money, you have 10 years to pull out all the money. And that is so that the government can start to collect some of the taxes on this money. Now, I've had a couple people ask me about spousal IRAs. And the rule for spousal IRAs is that if you have an IRA and you pass away and your spouse is the beneficiary, they can assume the IRA as their own. That is still in effect. So this only affects non-spousal beneficiary IRAs. The other question that I'm getting is, what happens to existing stretch IRAs? And so if the account owner is already deceased and there is an existing account, the Secure Act does not eliminate the stretch. So if you're currently under the stretch and taking money out on your own life expectancy, you will continue to do that. The new rule is effective for someone who dies beginning January 1st, 2020. There were also several changes to retirement plans for small businesses, and this is because there are a lot of small businesses that do not have retirement plans, and that statistic that I gave you at the beginning about a third of people not having money saved for retirement, a lot of them are people who work in small businesses who don't have the opportunity to save. And so the first thing is about multiple employer plans. So multiple employer retirement plans. These are plans where two or more unrelated employers come together to offer plans to their employees. And so the benefit of this is economies of scale, right? The more people that participate, the lower the cost. But there were two things that were really prohibiting people from joining MEPs. And one of those is that to participate in a MEP, the employers have to have some kind of significant common relationship, such as participating in the same trade association or being a part of the same, I know sometimes different types of specialty doctors are in some kind of group or organization together, so something like that. And the second thing that was prohibiting them is this one bad apple. So if one employer had some disqualifying event, it would disqualify the entire plan. Well, under the Secure Act, if a single employer fails to fulfill its obligations, the IRS is now saying we can just disqualify that employer's portion of the plan and keep the master plan or the MEP open to keep its status for the other employers. Now, this rule is not effective until 2021. There are also a couple tax credits that are provided to small employers. So one is just a startup tax credit of $500 to small employer retirement plans. And the other one is an automatic enrollment credit. So if you start a retirement plan and you automatically enroll your employees upon their eligibility, you can get a credit for that as well. And then enables businesses to sign up part-time employees that may not have been previously eligible. So there were some rules regarding who's eligible to participate. And the old rule is that you had to work at least 1,000 hours in 3 consecutive years to be eligible to participate in a 401k plan. And the new rule is that you only have to work 500 hours in 3 consecutive years. So it's really affects some of those long-time part-time employers. I'm going to skip, well, actually all of these are about retirement plans. So increases the cap from 10 to 15% for employee deferrals under an automatic enrollment. So again, with the automatic enrollment, if you have a plan and you automatically enroll your employees, there are a lot of plans will increase your contribution by 1% each year if they're automatically enrolled. So some plans, if you as the employee do not go in and select your percent of deferral and you're automatically enrolled, it could be increasing on you 1% each year. And it previously would cap out at 10, but now it's going to cap out at 15. So some employees could potentially be putting in 15% to their retirement. And the government really wants you to save money for your retirement. So in order to discourage people from using their retirement savings for anything other than retirement income, the IRS will charge a penalty for certain types of early withdrawals. Now, there are exceptions to the rule: death, disability, first-time home buyer for $10,000, certain deductible medical expenses, active duty. And now they're going to allow a withdrawal of up to $5,000 penalty-free from your retirement plan to help with the costs related to the birth of a child or an adoption. So that's going to be added to the exception list. Allows for new plans to be adopted by tax filing due date instead of calendar year end. And these are employer-funded plans, so like a profit sharing plan or a SEP IRA or a money purchase or a cash balance. So these types of plans that employers may want to open, but they don't know that they want to start these plans until they go meet with their accountant and figure out that they can save all this money, that they had a really good year, a really profitable year. And if they open some kind of retirement plan, they could share some of their profits with their employees and save some money on their taxes. Well, a lot of times employers don't know that until they go to file their taxes. And in the old law, you would have had to do this by calendar year end, and you may not even know that you want to do it at that point. So now the plan can be adopted as long as it's opened and funded by the tax filing due date. No more 401k credit cards. So previously you could have a credit card linked to your 401k and it would be connected to a loan. So if you've ever taken a loan out of your 401k, the credit card would be connected to the loan. So very few plans offer this anyway, but those who did will no longer. And the last thing is an option to include annuities. So this provision of the bill allows for employers to offer annuities as part of the retirement plan. And so in order to do this, there's some language in the plan document that takes the employer off the hook. And previously, employers wouldn't offer annuities because if they chose an annuity company that went into financial trouble, the employer would be on the hook. But within the Secure Act, there's some language in there that says, hey, the employer is still a fiduciary, meaning they need to pick appropriate products and annuities for their employees to choose from. But if the annuity company goes into financial trouble, the employer is not held responsible. And people like to have annuities because it can provide you a predictable stream of income in retirement. So it's an alternate to a pension. For years, academics have discussed the merits of having this type of thing in a plan so that when people reach retirement, they can start drawing off their nest egg. Annuity still may not be appropriate for everyone, so this is something that you should meet with your financial advisor or financial planner to talk about. Some other provisions: stipends and non-tuition payments received by students. So this is graduate or postdoctoral students that may receive a living stipend or some type of payment for lab research. You can't treat these payments as compensation. So before, you could say that they were earned income and make a contribution to your IRA, because you have to have earned income to contribute to an IRA. But you can no longer treat these as compensation. On the opposite end, if you are receiving a difficulty of care payment, you can use that as compensation to be treated as a basis for an IRA. And so difficulty of care payments. So this could be a foster care payment. It could be a payment because you are taking care of someone who is mentally, emotionally, or physically disabled. So several different kinds of payments fall into the difficulty of care. So if you're not sure if you receive a difficulty of care payment, reach out to your accountant. They would be able to help you with that. But you can now, so some of these people that were receiving these payments could not contribute to IRAs because they don't have earned income, but now you could contribute to an IRA or use these as basis for an IRA contribution. And there's a couple provisions that affect 529 plans. And so 529 plans are college savings plans, and you typically open a 529 plan to save for college or higher education. Now, with the Tax Cuts and Jobs Act that was passed in 2017, it allows you to actually use 529 plans to pay for private school and not just college. But now the Secure Act is even saying, hey, you can withdraw up to $10,000 a year from a 529 plan to repay student loan debt. So if you have a 529 plan or start a 529 plan and plan to pay for one of your kids to go to school and your child doesn't end up going to school, you could use that money to pay your own student loan debt or another child's student loan debt that you took out, something of that nature. And then also 529 plan provisions now cover the cost of apprenticeship programs. There were some programs that were allowed, but the language is more clear. So if you were going to do like a trade program, it does have some certain criteria that has to be followed or on some certain list, but there is language in the Secure Act that now says 529 plans can cover apprenticeship programs. All right, so what happens next? The first thing that I would tell you to do is know which laws affect you and your family's situation moving forward. So which laws affect you? Is it the laws regarding IRAs? Is it the laws regarding 529s? Is it that maybe you're a small business owner and now you can start a retirement plan, or you have a unique opportunity to receive additional benefits from starting a 529 plan? So know which of the laws are going to affect you, and then know when they become effective, because some are grandfathered. Some people might be in the middle of a period where they're not sure which laws, if they're affected or not. So knowing which ones were effective beginning in 2020 and which ones are effective in 2021. Evaluate your estate plan, as it could have been impacted if your current assets include a large retirement plan. So, and this bullet point really has to do with the stretch IRA, because people will have as part of their estate plan to leave their IRAs to their beneficiaries, because you could avoid taxes for a longer period of time. Well, not so much now, because you have to take out all the assets in 10 years. So if you think about it and you have a really large IRA and you have to deplete it in 10 years, that's 10 years where you could put your income into a higher tax bracket. So it may make sense to kind of sit down with an estate planning attorney, sit down with your financial planner, your financial advisor to discuss your current strategy. And as always, leverage your financial team for advice. I'm a firm believer that you need a team to help you. If you don't have a team, begin to build a team. Your team really should work for you and make recommendations that are customized to your unique situation. As always, I'm here for anyone who wants to talk. Happy to meet one-on-one, take a phone call, send me an email. As I mentioned earlier, I will be posting the webinar to YouTube. It'll be in there in the next few days where you'll have the opportunity to replay it and share it. Please feel free to share the webinar with your friends, families, colleagues, anyone who might be interested or benefit from the information. I look forward to an opportunity to help you and them and get on the right path and stay there. All right, I am going to go ahead and open it up for questions.